So I'm Jeff Nelson. I'm the chair of Washington Lawyers for the Arts. The office reached out to us to help find a speaker for events, and one of our friends and colleagues is Ashley Long, who's of counsel at Carney Badley Spellman, where she's a business and IP attorney. So I just wanted to take a couple minutes and tell you a little about WLA and the work that we do. So our role is basically to connect artists with legal services, and we do that by providing free legal aid clinics a couple times a month. We have a referral program where you can email or call in with a pressing legal issue, and we'll find a lawyer in your area to assist you. We offer speakers for local organizations that need help, often in IP or business or tax issues. And then we offer monthly workshops where we have presenters talk about legal issues that affect artists or arts organizations. We're statewide, but mostly focused on the Puget Sound area. So you can find more information at thewla.org, or please ask me any questions that you have. I'll try to hang around for a little bit after the talk. But without further ado, I'll let Ashley take over.
Hi, everyone. Thanks for coming out tonight. I am not off book, so we're just going to assume I'm cheating with this tonight. Thank you all for coming out here. As Jeff said, I am an attorney, and I'm really glad that it's encouraged you to attend and not run screaming in the other direction. It's a good sign, good sign. But before I was a lawyer, I actually was a bigger part of your world. I was a theater major. I focused on acting, worked in the costume shop, scene shop, directed, and wrote plays. So at some point, I decided my brain was better used behind the scenes than on stage, and that's what's brought me here today. So what we're going to talk about is the legal landscape of our virtual world, the intersection between the speed of media and content versus the glacial slowness that is the law. Some of you may recognize our friend there. Classic. Also, Chicago is hosting a 4-day Ferris Bueller Festival at the end of May, if any of you are interested. All right, so the world has changed a lot in the last 10 years. 2005, Facebook was still restricted to a handful of universities. And at that point, no one had even heard of a tweet. Twitter's 10-year anniversary is at the end of next month. So we had blogs, we had websites, but those involved effort. And now anyone can pretty much infringe, misappropriate, take content in a moment's notice and under 140 characters. So the question becomes, friend or foe when it comes to figuring out, is the speed at which we can access content, distribute it, copy it, and send it to other people, friend or foe? The speed of law and the speed of technology are basically entirely incompatible. Clients have come to me more times than I can count, talking about how frustrated they are that somebody posted something of theirs online and they cannot get rid of it now. So before you leave here tonight, my hope is that I'm able to give you some means of not only better knowing what your IP actually encompasses, and also how to protect that IP. Also, if you guys have questions, just come up to me at the end. All right, so how do we bridge this divide? Entertainment law. It's kind of a misnomer. It makes you think it's just one thing. But ultimately, it's a cross-section of a lot of different areas of the law. It includes your basic contract law, right of publicity, privacy law, and intellectual property law. Since you could spend 3 years in law school and still only scratch the surface of any of these areas, and I can attest to that, we're going to focus mainly on the intellectual property part for tonight. Okay, so 3 main camps to intellectual property: patents, trademarks, and copyrights. The first camp is patents. So that deals primarily with inventions. I am not a patent attorney. I don't ever want to be a patent attorney. I did patent litigation and it sucked my soul. So I will briefly speak to it and then move on to areas which I like and actually understand. So primarily patents deal with inventions. They're absolutely a part of the entertainment world. We'd see them in any technology you develop. So if you're creating new booms for cameras, that might be patentable. But I would be talking out of my ass if I went much further on this. So if you've got a really great idea for a new like Fresnel lens or boom, that's awesome. Come find me afterwards. I'll refer you to a patent attorney or attorneys that I like and who don't suck, and we'll find out if they're a good match for you. What I can tell you is this. If what you're trying to patent isn't new, or if it's been done by somebody else already, you're unlikely to get a patent on it. Also, it has to be useful. And before anyone asks, because I get this question a lot, you cannot patent ideas. So, yeah, sorry, got to make something out of them, or at least plan to make something out of them. All right, copyright and trademark. In my world, we call this soft IP. Hard IP is patent, soft IP is copyright and trademark, maybe because, I don't know, it's fuzzy bunny stuff. We like each other, we're creating things, we're branding things, it's all really happy. So soft IP. It gets confused all the time. I can't tell you how many news articles I've read where a journalist is mixing up a copyright and a trademark. So part of the reason we're so confused about how to protect our IP is because we don't know what it is. To be completely honest, most lawyers don't know the difference either. I have partners walk into my office and they're like, hey, can I copyright my trademark? I'm like, no, not for your client either, so that's too bad. So the next time like Kanye starts complaining about how Taylor Swift stole the dictionary and all the words, just ignore him. And think back to tonight's lesson, and hopefully you'll have a little bit more ammunition in your own building and representation of your IP portfolio. So, as a basic thought, trademarks protect brands, copyrights protect expression. Talk a bit about both of those. So trademarks, they are brands. They can be manifested in any number of ways. You can kind of think of it like an equation, like something, either a word, a logo, a sound, a smell, plus specific goods or services makes the consumer think of you. So I love this example from Clueless, where obviously the dress is Calvin Klein. For example, in a more practical sense, if you see the swoosh symbol on the side of a shoebox, you automatically know that that's Nike. And that's the idea with trademarks, is that you build a consumer association and recognition. So whether it's the bum, bum, bum for TV stations, or whether it's the smell of a particular kind of thread, there's actually a trademark for plumeria scented thread out there. It could be the cherry red lacquer on a Louboutin shoe. All of these things make you recognize a certain source, and that's what really sets trademark apart from the other areas of IP. Copyright. A lot of you are creating content. Maybe most of you are creating some kind of content. So copyright is the expression of that content. Again, while you're just thinking of it, ideas, as long as they're in your head, you can't protect them yet. But once you express them with enough original content, then you will have some kind of protection under copyright law. And copyright law covers a whole range of mediums. So whether it's architectural, sculptural, the written word, film, now choreography is finally protected. These things all are expressions of something you've created, but the idea being that they are expressed. Okay, how does intellectual property affect you? As artists, you guys are creating works all the time. However, you're also brand owners as well. So as you create these brands and you create these works, ultimately the job is yours to figure out how to build, protect, and enforce them. The law is only going to give you help if if you seek it out. There's no like Papa in the sky who's going to go out and make sure that nobody's infringing your stuff. There's no parental unit who's going to keep your IP protected. So you've got to keep the eye on it to make sure that it's going to stay safe. All right, let's think a bit about creation. As kind of a general rule of thumb, the law protects the person who creates something first. But just because you're the one who created it doesn't mean you are its lord and master. There are metes and bounds to this. Also, this is just the rule in the US, so pretend that the rest of the world doesn't exist, or talk to attorneys there if you wonder if you have rights outside of the United States. Now, first in time, first on the market, what have you, it's a general rule to which there are a number of exceptions. Real property, defined by its metes and bounds. IP can function the same way. It's just really a question of how you use it. And the exceptions that might be included in this involve uses by third parties, which are totally authorized and totally legal. All right, I love this image. Both copyright law and trademark law protect certain kinds of third-party use. Some of you may be familiar with the concept of fair use. It's an affirmative defense to copyright infringement that's applicable, well, to infringement, and it has bases in both copyright and trademark law. So as an affirmative defense, basically that means that, yeah, you may have appropriated something, but it's okay, and here's why. The law is there to recognize that some of these uses of IP serve a really important secondary purpose. Sometimes they provide commentary or criticism, or they're used for an educational benefit. Also, the way the third parties utilize this material serves this function in a way that transforms it from its original state. For example, the shirt that you see here, I'm sure many of you remember the Obama Hope shirt and the Associated Press scandal that kind of grew out of that, along with Shepard's Ferry's claims that this was in fact a transformative work and it was fair use under copyright law. That one settled out of court, so we don't know how ultimately it would have come down, but because the use was arguably not transformative enough, AP was saying it's theirs. Now in this case, it's pretty damn transformative. No one's questioning that's Obama. No one is denying the fact that having a comb over could attract eagles. So yeah, this one, if Trump's group, exactly. So if Trump's group came in and tried to get a cease and desist on this one, I think they'd be a little hard pressed to win. All right, thinking more about the scope. Again, coming back to the news media, Kanye, whoever is shouting loudest that day. We heard when Taylor Swift did Swift Miss in 1989 that she was stealing the dictionary, and basically no one was going to ever be able to say or use those words ever again in anything, anywhere. That's not true. Trademarks are attached to specific goods and services. So if I wanted to brand something Swift Mist for maybe quickly assembled Christmas ornaments, I don't know that Taylor Swift has grabbed up that space yet. Maybe I could still get it. So the idea is that if you are seeking a trademark for something, it doesn't mean that you get exclusive rights to that word on everything in the conceivable universe, only what you are actually branding it for. The exception to that being if you are one of the Uber marks like Apple, Victoria's Secret, where if anything is slapped with those, people will think that it's probably associated with the brand owner. But those are a very high tier of marks which, because of their fame, get kind of extra protection. Most of us will never see that fame. Maybe that's a good thing. All right, another consideration is that sometimes what we think is IP or could conceivably be IP isn't actually IP at all. We create something, but just because we engaged in the act of creation doesn't mean that what we've created is protectable. So in copyright, the area we see this in, for example, is useful articles. If you create something that's super utilitarian, has no independent aesthetic component to it, like a stairwell maybe, even though, yeah, you might have been the one to design it and do the CAD drawing of it, if there's nothing original there, it doesn't mean it's yours, and you can't borrow the rest of the world from creating a utilitarian stairwell just like the one in the building next door. So even though you engage in the act of creation, it doesn't mean that you're necessarily given extra protection from the law. Trademark front, we see this a bit too, because when I have clients come to me, and I'm sure, Jeff, you hear the same thing, people will say, I want to trademark this word, and I'm like, that's great. you totally described your product, and it's going to be really, really hard for anybody to know that it's you, as opposed to the dictionary words which you are using to describe the product, which all of your competitors will also use to describe the same product. So the idea being, like, if you want to stand out from the crowd, you have to think, like, maybe I need to get away from these utilitarian things or these very descriptive things and actually stand apart and get some unique IP that will then adhere the legal rights to it. All right. The reason I go on about trying to figure out what's copyright, what's trademark, is because once you know where your intellectual property lives, you'll be able to better enforce it. So for this piece, we're going to talk a little bit about how you can protect your IP. Some of these routes, like registering your IP, are traditional. Some others will allow you to navigate enforcement with much greater ease. So registration. For patents, there's 3 different types you can seek out. Provisional is kind of the preliminary one. It can convert into something called a utility patent, and these are for basic, very utilitarian functional things. A design patent can cover certain aesthetics. For trademarks, it can be just a word mark, it can be a logo, it could be the packaging of an existing good, or it could be the configuration of an existing product, the Coke bottle being the most famous configuration. Copyright can also be registered and should be registered. Registrations are categorized by type, so literary, film, music, sculpture, what have you. Okay, but why would you bother doing this? There are the usual legal rhetorics about why you'd bother getting these done. There's a presumption of validity. That means if you go to court or you go to somebody with any kind of adjudicative presence, you've got a certificate in hand that somebody else has to try to shoot down. Exclusivity. In the trademark world, if you've got it on certain goods, a nationwide registration will allow you to shoot down people in other states who are trying to adopt. Custom registration. If you've got goods being imported, exported, this will allow you to get rid of counterfeits. Injunctive relief at the courts. Now, this is one that is actually quite important because absent registration, it's really hard to get somebody to stop doing something. You can go ahead and draft and send a cease and desist letter to somebody who's ripping off your stuff, but who's going to enforce that? They're just going to say, no. So the courts are the only ones ultimately who can issue an order that will stop somebody from distributing either infringing or counterfeit product. So if you've got something that's copyrighted, especially, you can't get injunctive relief from a court absent a registration. So it's a good thing as you're creating things. It's like $45 a pop to do a copyright registration, to go ahead and be getting these important things registered so you can protect them. Also, better damages. In the case that it goes the distance, you can get up to triple the damages for infringement if you've got that registration in hand. All right, now practically speaking, what good is registration? Has anybody in here ever found something of theirs online that they did not authorize? All right, so we've got some hands going up. Many websites now allow us for a very expedited process for getting rid of unauthorized content. Facebook, for example, will usually, if you've got a valid either trademark registration or copyright claim, will remove content in like 4 hours. Twitter's a little bit slower. Snapchat is the devil, and there's no way to fix it, sorry. We're just shit out of luck on that one. But YouTube is great, and in fact, if you've had multiple incidences where you've had to pull down content, they'll set up an account for you so you can streamline the process and basically click through videos that are infringing, and they will just pull. So the thing is, if you've got your portfolio in shape and you're recognized as the owner, this can make your life so much easier in terms of getting rid of unauthorized content. This is true too in terms of domain names. A lot of times you'll come across a domain name that is basically redirecting traffic. It should be yours, but it's not. You didn't grab it. And so what you can do is go to the hosting provider, the registrar. You can submit complaints saying, hey, like somebody's appropriated my trademark. There's even a arbitration proceeding essentially that allows you to do this where you don't have to go into the court. The other option is if you find out who it is, you can throw $500 at them and hope that they transfer it. which at the end of the day, hey, it's a business decision. Questions at the end if you can. But yeah, sometimes it's just the kind of thing where do you go to court or do you just throw somebody $500 and call it a day? Might be better to do that, but at least there are faster ways than having to go into a courtroom. Nobody wants to go there. All right, you've got your IP, you know what it is, and now you're like, yes, I know how to enforce it. I can go do all these things. A consideration is just because you can doesn't always mean you should. We've got some cosplay folks over there on the left. We've got the bat lift on the right there. Really, at the end of the day, it's, again, a legal decision as much as a business decision as to whether or not to enforce your rights against a third party. Something like this might actually be really good advertising for you, positive PR. So if you come down on someone hard with a nasty gram from a lawyer who looks like they haven't stepped outside their office since the 80s, then you're going to be making a big PR whoopsie when really you could take that person who maybe didn't start off as an authorized user, get a license in place, get the rules on for how they can and can't use your IP. Great, now they've won, you've won, and you've got free marketing out of it. So a big part of it is considering, now that I have it, like how do I use it and what's the right choice? Kind of a final thing is to be careful what you wish for, because whereas we love the idea that fans, consumers, visitors to sites are going to run with what they've seen, sometimes that dissemination can happen so fast it can actually be hurtful. I've had a lot of people come to me and ask if they can go ahead and register hashtags. You kind of can. We just call them like tag marks, basically. But at the end of the day, it goes back to this idea of if you use really descriptive words in doing that, nobody's going to know what it is that you have. So you have to think carefully about, like, if I'm picking something straight out of the gates, do I want to be unique and be able to build it as a brand, or do I want to be descriptive and possibly have everybody using it, blowing up as a meme, and then 48 hours, nobody knows or cares what I did or who I am? So careful branding is also a consideration. So now you know a little bit about the different categories of your IP, how you can maintain it, and what things to be thinking about in terms of enforcement to keep that portfolio in really great shape. I wanted to keep this short and sweet tonight, but if any of you have any questions, feel free to come up and ask me. Happy to also buy you drinks and coffee for future times if anyone has to run out of here. Contact information is there, and I also have cards on me if you need them. Thanks, everybody.